Welcome back, everyone. My name is Mark Reel Jr., the Father's Rights Attorney, and you are watching another episode of the Father's Rights Playbook. And on today's episode, we have a returning guest, new role here with the firm. We have Managing Attorney David Taub. David, how we doing?
We're doing terrific, Mark. Thanks for having me back again.
Awesome. So on today's episode, we are going to not necessarily talk about the law, not talk about any specific part of the family code, but we are going to talk about the power of settlement. So I'll kind of open the floor to you to kind of start us off here. The power of settlement. What does that mean?
Well, I appreciate that, Mark. I got to preface it a little bit, a little bit here. We're fathers' rights, and we're parents' rights, and we want to make sure you are getting as good of a deal as you can, whether we bring it to the court and we argue, we bring in testimony, we put you on the stand, we try to get you the best situation that's going to protect you, protect your relationship with your children, and get you through the whole process relatively unscathed. Now, that said, we have our fair share of clients, and I don't blame them. They're ready to fight, and they brought us aboard to fight as well and to litigate. I leave no stone unturned, Mr. Taub. We want you in there like a bulldog. We want you to fight. I then explain to the client, I say, that's all fine and good, but you got about 20 issues on the plate here. Are you ready for a 20 to 30-day trial, which is going to cost, it could cost $50,000, $100,000 for such a thing. And the reality is most of you don't have that. And we don't want to race through that like, through a goose. There's other ways to do this, and it's called settlement. And the old line, it still holds true today. You're not going to get everything that you want, but you're going to be in a lot better of a place that you went forward and you reached out to the other side and came up with an agreement. It has several advantages, Mark. One of them is you will come out of the process with more time and custody with your children for the most part. You will get more. In my experience, you get more than halfway. You get almost all the way to that goal of a solid win. But there's a little give in settlement where the other side is going to come out a little ahead as well. But I'll tell you, between the cost and the time involved, and most importantly, you have a judge that thinks your client and you are the most terrific people in the world because you went out in the hallway for a couple hours and you settled. It is an avenue toward getting most of what you want, and my clients almost all the time are happy, they're satisfied, they got their time with their children, and they took this excellent alternate avenue that got them into court, got the judge to make that order, but they didn't spend 20 days doing it. That was more than an intro, Mark. I'm sorry. Go ahead.
No, definitely. That was great. Because I think that the number one thing that a lot of times we really have to get into our clients is you just want to grab them by the shoulders and shake them is like, as long as we know what you're willing to give on, you're not going to get 100% of what you want. But if you could get 75% of you want, and let's say there's 8 issues, and you can get 6 of the 8, and those are the 6 most important. Well, it probably makes a lot of sense to take what you have in front of you. There's a time and a place to litigate. There's a time and a place for those trials, and I think that that's something that we see day in and day out. But the vast majority of people would be better off and move on to their next chapter of their life in a better spot if they were okay losing on some issues that aren't as important to them, but getting what really matters to them.
What really matters for the most part, I think, is always the parent's relationship with the child. The judge is aware of that as well. The judge looks at the two parents as they're squaring off against each other. Is that judge thinking, I'm going to benefit one parent or I'm going to benefit the other parent? Absolutely not. That judge is looking at what's best for the child. Always the case of what is in the best interest of the children. And under the California Code, that best interest is for each parent to have as much continuous and frequent visitation with the child as is reasonable and as will protect the best interests of that child. 90% plus of your cases, each parent is going to get significant time with the child. If my clients are able to understand that and know that it is not such an extreme that they're going to get 100%, and the other parent's going to be blocked out, if they understand that, hey, there's going to be some give here, that judge is not going to give an absolute 100% victory to you, they usually wake up and they say, you know what, go talk to opposing counsel. I'm willing to work with the other parent.
Yeah.
And it almost wakes up the client for the future, where they realize, wait, I can negotiate with the other parent. I can set a certain pattern where I'm going to co-parent with the other parent to raise our child in a very difficult paternity or divorce situation, which is better for the child. And again, the judges, they love that situation. They will congratulate you and the other parent, saying, well done. And sometimes they'll say, you did what maybe your attorneys couldn't have done in this situation in such a short amount of time, because you stepped up and you worked with your counsel and you worked with the other side. And that's what the judges love to see.
Yeah, well, I think you made a really good point about the co-parenting is going to extend the relationship with the other party. Your co-parent is going to extend well beyond the court date you're currently at. And you and them, even if you don't see eye to eye on so many key issues, the two of you making a decision is going to be a better decision than the judge could make. And it benefits moving forward because you're going to have to co-parent in some form or fashion no matter what.
Absolutely. Look, you're going to be co-parenting until that child's 18. You're going to be walking with that child, perhaps down the wedding aisle right in front of them, or leading them in. And that other parent in your court case is probably going to be right nearby doing nearly the same thing. So you got to put on your best face. You got to keep working with that other parent, whether you like it or not. And I'll tell you, a settlement's a good way to get the ball rolling, and it helps to bury a lot of resentment that built up to the trial. And some parents really turn it around for the better for themselves and for their children.
Yeah, I think that's a big one. You mentioned it. It extends beyond 18 or 19 high school graduation. I mean, realistically, the rest of your life, you're going to have some form of communication and relationship around this person. There's really no way around it. And starting it off on the right foot, no matter how, we understand a lot of custody cases, a lot of divorce cases start out as DV cases, and it's
Sure.
nasty and it's tough and it can be really, really challenging. But to find some way to leave the courtroom getting what you deserve, most of what you want, and moving on to the next chapter in a lot better place than some people, they just burn it to the ground and they never really recover. And it can be a miserable existence for decades because of it.
You know, here at Real Fathers Rights, I work with 16 or 17 seniors and associate attorneys. They're not machines. They can turn it on in an instant. And they can go bulldog in the courtroom and fight. But they're also empathetic. They're human beings. They have families, and they understand what you're going through as well. And we're willing to work with that client. We encourage that client to look at all avenues, including what can we do to settle this down. To settlement, the term settle does not mean surrender. In a lot of these cases, the term settle means let's come up with the best solution for the children and for these divorced parents, because they've been through hell and back to get to this point. And part of our job as counselors is we do counsel. We do try to bring down the friction, bring down the anger, and come up with something that protects your rights, your children's rights, and gives you an avenue toward that future to work toward a more positive relationship with the party you've divorced or separated from.
Definitely. Well, David, thank you so much for your insights. To our listeners, to our viewers, thank you again. And we will be back next week with another episode of the Father's Rights Playbook.